world of social distancing. So we're working very hard on that. I hope you are taking advantage of the Zoom programs and Facebook Live events. Also, there's a Google Duo. I don't know if you're familiar with that. That's another option you can use. We have been offering to help you increase your virtual toolbox or to give you the information you need to navigate these uncharted waters. Today's legal update is a chance to get some guidance and talk about some of the things that should be on your radar during these unprecedented times. In addition to what we discussed today, I encourage you all to visit the Arizona Realtors coronavirus resources at www.aaronline.com/COVID-19/. And the National Association of Realtors coronavirus resources at www.nar.realtor/coronavirus. And watch out for any updates from PAR via the email and or posts on Recess and on Facebook. But I know you didn't come here to see me. Instead, you came here for Jesi. Hi, Jesi. I couldn't hear you.
Oh,
there you are. Okay. I wanted to make sure before you started talking. Jesi, who is well known throughout the real estate community for her knowledge of legal issues and concerns of real estate professionals. She brings more than 19 years of experience as a licensed real estate broker to her practice, and Jesi handles a variety of professional liabilities issues for real estate professionals, including real estate licenses and escrow agents. She frequently serves as outside general counsel for the brokerages needing legal advice and representation, but who do not require on-staff attorney. Jesi also assists brokers during audits or investigations by the Arizona Department of Real Estate. First things first, we want to remind all of you that although Jesi is an attorney, she is not your attorney. Okay, so by joining us today, she is not acting as any attorney for any one of us, but instead is here to offer guidance and advice as we continue to make sense of these new requirements. If you need specific legal guidance, you will need to reach out to your own attorney, and if you are a designated broker, you can reach out for assistance via the Arizona Realtors Legal Hotline by calling 602-248-7787 or 1-800-426-7274. So let's get started. So Jesi Wolnik, thank you for being here with us today. One of the questions a lot of realtors have been asking Jesi is, what exactly does it mean to be an essential service as a realtor?
yes. And just a disclaimer, you can hear me okay? Yes, Jeff?
Yes.
Just a disclaimer, I answered the call to action and I adopted a puppy 2 weeks ago. So you might hear yipping in the background, so I apologize now. Okay, so essential services, that was defined in an executive order by Governor Ducey. If anybody wants to see it, it's Executive Order 2020-12. And of course, they're in order as how they were issued. In that order, they say an essential service is one specifically identified as a function that promotes the public health, safety, welfare of the state, or assists others in fulfilling those functions. In the order, it does state that this definition is to be interpreted broadly. And so they're trying to not make it restrictive. If there's a question of are we essential or not, often they may say, yes, it is essential because it's linked. For example, in paragraph 19 of that order, it says professional and personal services such as legal services, accounting services, insurance services, and real estate services. And it specifically includes appraisers and title services. So they do call out in many states, or I should say every state is able to determine if real estate services are considered essential. Some states have determined They are not essential services, but it's important to know in Arizona, the governor has determined real estate is an essential service.
Okay, fantastic. Would movers, would they be considered falling underneath that realm because the people have to get from one place to another? So would a moving company be considered an essential service under the real estate?
I think it's important not to answer that question if you're a real estate agent, because that could be giving a legal opinion to your client, and that opens us up to liability or risk. You can say anything that's factual. So in fact, the order says this is to be construed broadly. So it could be, I think, determined movers, anything associated with moving, but we don't want to say definitively yes. That would be a legal opinion. And so we should tell them always just to consult their attorney, or if the movers think they are an essential service, they should consult with their attorney to confirm they believe they are an essential service.
Excellent. Okay, thank you. I know it helps me to think about it as not as a business as usual, but as business as unusual, or business with precaution. Now that we are under Governor Ducey's stay home, stay healthy, stay connected orders, does that change anything for our realtors? What about our clients and potential clients?
You could really go down a rabbit hole, which I have done, trying to answer this question. There are so many great resources out there. You mentioned a few. AAR has a great resource page. NAR has a great resource page. Those are two really good resources. And so to begin, realtors should endeavor to conduct as much work as possibly remotely. And that is advocated by the National Association of Realtors. So they have asked, as much as possible, realtors please work remotely and follow the CDC guidelines, which of course prevents the spread of COVID-19, which we're using just this common term, COVID-19, coronavirus, COVID-19. There is a scientific name, but we'll stick with just this general term that most people are familiar with. And of course, the CDC says 6 feet away, no more than 10 people, wash your hands, etc. So if you go to NAR's website, and I believe AAR also replicates it on their website, those guidelines are there for you. There are different guidelines for stay-at-home orders. I liked this example, the Maryland Association of Realtors, so not our state. They gave a list of guidelines that should be followed for their stay-at-home order, which said, and this was from the Maryland Association of Realtors. Now on their website, they said, in-person activities must be by appointment only. No more than 3 people allowed at the property at a time, including the agent, and social distancing guidelines must be adhered to. I thought that was a good policy to have. Then there was the Denver Association. They said, only work with clients who truly need to buy or sell right now. If your buyer or seller can wait, provide guidance with perhaps suggested temporarily pausing a listing. So I mentioned those two just because as I was going through all the different state associations, I thought, wow, for stay at home, not the more stringent, your stay in place, you can't leave, but stay at home is a general stay at home as much as you can. So I liked the example between the 2 state associations. One state is saying, don't go out if at all possible, try to actually discourage your clients from showing or shopping for real estate unless it's absolutely necessary. So we're not there. Our state association is saying we are an essential service. We need to conduct business as usual, but follow these guidelines, which is what NAR is also promoting, which is work remotely as much as possible and then follow the CDC guidelines.
Okay, fantastic. So in our relationships, as I mentioned before, moving companies and that, in addition to our clients, some of our realtors are asking other services such as photography, inspections, and other services utilized by part of the listing and closing property transactions that are not considered, or are they considered, an essential service?
Sorry, I'm jumping to my different notes here. Okay, so you asked about photographers, inspectors, etc.
Exactly.
There's an executive order, again, 2020-12, that again identified appraisers and title examiners or title companies specifically as part of that essential service. Paragraph 15, I took notes on paragraph 15 that essentially said, if you provide supplies for essential businesses and operations, with support or materials, including, and they list computers, audio and video electronics, and photography equipment. And again, stating that those guidelines should be broadly interpreted. So that could be interpreted to include home inspectors, photographers, contractors, but it's, again, best for members not to provide a legal opinion, because again, that when we, go out and make a definitive statement, one way or another, it could be determined a legal opinion, and now have we opened ourselves up to risk or liability. And so we know we can say appraisers and title companies because it's specifically listed on the order. Anything other than that, really, we should be having the service provider that we're questioning whether they're essential, have them speak to their professional guidance, attorney or whomever, to determine if they are an essential service.
Understood. Good advice. Okay, so I know I have been doing a lot of thinking about what is essential and what isn't essential for a real estate transaction under these new conditions. One of the things I think many of us are pondering: in-person open houses. As an association, the Prescott Association of Realtors Multiple Listing Services we turned off our in-person open house function or feature and temporarily enabled the virtual open house feature, since we feel it is important to do our part to keep our members and our community safe. But we also understand it is a personal business decision. Do you have any thoughts on in-person open houses and if they are an essential part of the real estate transaction under these conditions? And how many, or how give us some guidance not to have more than 10 persons gathering, affects in-person open houses, that sort of thing?
Sure. Again, there's a lot of information out there because this is one of the big questions. Part of our real estate activities would be open houses. And so is that advisable? And if so, does that lead to liability potentially? So as far as open houses and guidelines, again, I'm in line with what NAR recommends. NAR strongly encourages members to consider the advisability of continuing to hold open houses at this time. So in other words, think twice before you agree to do an open house, especially in light of the guidance and actions of federal, state, and local authorities, including the president's coronavirus guidelines for America. That includes gatherings of no more than 10 people at a time, 6 feet away, etc. So NAR has a great resource on this. You can click, they have a whole section about open houses, and they remind you that you are never required as a realtor or even a licensee, regardless, right? You are never required to put yourself at risk in servicing a client. Have an open and honest conversation with your client about your concerns with holding an open house, including whether doing so would contradict current government recommendations or mandates. And it's important to let your clients know that you will continue to service them and that you can continue to market their home using an array of technology, especially as you mentioned, there are a lot more virtual opportunities now because everybody's trying to cooperate and still follow these guidelines of the stay at home. So if after discussing the issues, you and the client mutually agree to hold an open house, advise your client about necessary precautions to minimize exposure to and the spread of COVID-19. And you should ensure that, again, guidelines are followed. Less than 10 people are touring the home at any given time. And you could consider allowing only one buyer group to tour the property at any given time. You have to follow the guidelines. They should wash their hands, use alcohol-based hand sanitizer before they enter the home and after they exit the home. There is a question of whether they should remove their shoes, or you can get those shoe booties to cover their shoes. That would be advisable. Also, very recently, AAR issued a model example. It's you can find it on AAR's website, and I believe it was also provided as a link through their latest Realtor Voice publication. And it is a model COVID-19 certification for property access. And I don't know if you'll be able to see it, but that's what it looks like. And it gives the address, the agents for the seller, agents for the buyer, also landlord, tenant, of course. It says other individuals. So you could use this even if an appraiser was entering the home or a home inspector was entering the home. And then, no, this is not a waiver, but it's more of a notice, I guess I would call it. And it says, each person listed above certifies that to the best of his or her knowledge, neither they nor a member of their household, nor a person with whom they are in close contact has, and then it gives a list, experienced cold or flu-like symptoms, been diagnosed with COVID-19, etc. And so it's almost like your open house checklist sign-in sheet, right? But this is more of a checklist that says, if you have been exposed, maybe we can deny entry. We don't want you in the home. So I know we're going to talk about fair housing, but as long as this is applied evenly across the board to everybody, this is a model that AAR has put out as an example for you to use if it is determined the seller's going to allow people into their house.
Okay, fantastic. So that would go both sides. So you're talking about your sellers and your buyers. Everybody is on the same page with that. And so is there anything specific for buyers agents to know with their buyer when viewing homes, other than what you just mentioned with the cooperation on the form to fill out to let everybody know whether or not they've been exposed and that sort of thing? Is there anything specific that you can think of that the buyer's agent should know before bringing them to a viewing?
Well, we can talk about buyers in general, perhaps. For buyers, I hear a lot of agents making a decision not to drive buyers around anymore. Now it's, I'm in my car, you're in your car. And then again, I don't think it would be a bad idea to use the property access form. That way you've, made your due diligence to ask. Maybe you feel awkward about saying to somebody, have you traveled recently? Have you had a cold or the flu recently? Or that could be difficult for some people. So that might be this form by AAR might be a great tool to broach that conversation. And there are questions about, gosh, people can get sued over anything these days. Do we have to worry about now liability for us because we've allowed people in and they had COVID-19 and we didn't know? And again, we'll talk about that. But here now we've done some due diligence and we've asked them and they answered yes or no. And so there was no red flag for us, right? So we proceeded with letting them view the property.
Okay, fantastic. And so you're talking about being sued, and also we're getting into the fair housing thing too, as far as how we treat each customer that comes to us the same way, the same fair way, talking about whether we have them follow us or we offer to drive them around. We have to kind of keep the same tone, correct, for everybody that we deal with. So can you tell us a little about that?
Yeah, and I would remind everybody, April is Fair Housing Month. So great topic for us right now. The biggest thing for me for fair housing is you must treat everybody the same, okay? We've seen those horrible stories in the news where individuals who look of a certain ethnicity are being harassed. If the individual looks Asian and everybody thinks coronavirus began in China, oh, we need to discriminate against them. It's unfathomable, but we see those stories in the news. So for us, as a population realtors, we really strive and have high standards regarding fair housing. And so I think business as usual. I shouldn't have to tell you all what you already know, correct? And so fair housing guidelines are, we treat everybody the same. And so that again is back to, we use that property access sheet for everybody. If you're going to screen clients, you ask them all the same question. Everybody should have that access sheet in their file. If you've used it for one person, now you use it for everybody.
Okay, fantastic. All right, how about a difference between vacant and occupied houses? Is there something that can be relaxed in a vacant as opposed to the occupied, or what's your opinion on that?
My opinion was no. I think you treat them the same, and I can give you an example. I do know of a house. I shouldn't say I do know. Many houses, even though they're vacant, sellers still going back frequently. Maybe they're still clearing things out. You don't know what buyers have been in just before you. I think we treat vacant and occupied properties the same as far as precautions and guidelines.
Okay, fantastic. The obligations are different for brokers. Do you have any advice specifically for designated brokers to help them make the necessary adjustments to serve their agents and help their agents serve their clients during this pandemic?
Sure. So again, NAR has some good guidelines on their website for brokers. Brokers should have an action plan, and they give examples on their website. Some of the takeaways I took from there would be promptly communicate with staff and agents how the order impacts their ability to conduct business, right? That might include, hey, the office is going to remain open, but we limit who's in there. And if you don't need to be in the office to meet clients, if you have to meet them to sign something because they don't have a computer or something, then it's only by appointment and because it was absolutely necessary. So communicate, and I'm not saying that is the rule. That's as an example, if that was the broker's policy. So broker has to have a policy and let the agents and staff know what their policy is. Again, somebody should be in charge of keeping track of how many people are in the office, so we have no more than 10, and that social distancing is being used. Staff, we need to decide if they should be encouraged to or permitted to work at home. I know one broker, she has the entire staff, and she's got quite a few working in her brokerage. Normally, they all work remotely now, and they only have just the receptionist that goes in so she can answer the phones and deal with any incoming faxes or things, but she's the only person that's there. So that was that broker's decision. And again, just you're supposed to, as a broker, it's advised, I should say, to have a preparedness plan in place to be ready to respond to any COVID-19 issues.
So even as an independent, you would have a plan for that?
Yeah, I could give a really good example. When it rains, it pours often. I was contacted last week by a broker who, received a letter in the mail that they are going to be audited. And so they called me to hire me to assist them through their audit. And again, making matters worse, it ended up that they are stuck in another country. They had senior parents in another country. Parents weren't able to travel back because they were afraid of traveling back as this all started to become more and more of a concern. And so the parents were stuck in a foreign country. So the broker decided to go to the foreign country so that their parents wouldn't be in a foreign country alone. So now they're remote working from another country, trying to respond to this audit. And thankfully they did have a plan, and they have, all of their documents online. And so they were able to respond and no disruption in business, and they're moving forward with everything. But to me, that was a great example of having a plan for a response during this COVID-19 pandemic.
Okay, fantastic. And I would suspect that all the brokers out there would want to find out about their E&O insurance, correct?
Yeah, with E&O policies, there's no answer for me to give. Yes, you're covered. No, you're not. If you contact your insurance broker, that's probably the best resource for you as a broker at this time. There are so many different policies out there. again, I'm in a fortunate and unique position where I do help a lot of brokers with their policy and procedure manuals. And part of when I go through that is, right, I discuss what their E&O policy has. And because I do that, I'm able to see just how many different policies are out there and what's covered here and what's covered there. So that's even one thing I just normally will recommend to brokers is, hey, you need to reach out to your E&O broker and ask these questions. So I'm going to give that same advice here now. If you have a concern about will your E&O policy cover you, should there become a claim against you as a result of the COVID-19 pandemic, you really should reach out to your E&O broker to discuss and determine whether or not you would have coverage. Again, it's more of an insurance industry issue, but there's conversations about most insurance policies have a mold clause, right? Where if mold is involved, then your policy won't cover it. Now, mold is a bacteria, they're saying, and COVID-19 is a virus. So the insurance industry is saying, well, is it covered? Is it not covered? So there's not a definitive answer right now. It really is best for brokers just to contact their insurance broker and follow through to see how this evolves and whether or not coverage would apply.
Wow. Okay. Thank you very much for that.
Yeah.
In this plan that we're trying to create so that we can keep everybody on the same page and all, should we be, and we've been pretty fortunate out here from what I can gather, information that I'm getting is that we're still having listings, we're still having people that want to sell, and so should we be having different conversations about the service providers who will be entering the homes as part of the transactions, such as the appraisers and the home inspectors? Should we be having that conversation with our sellers?
Yeah, absolutely. It's important to have that conversation. Communication is going to be key. You need to know what your client's concerns are and whether you're able to help alleviate those concerns. Again, I think the COVID-19 model certification form from AAR is a great way to broach that conversation and explain, and again, as a attorney that represents many brokers, I'm getting a lot of calls from all over the state where they're saying, our numbers are way up. I've had more sales this month than I did last year at this time. And so, I mean, we can't predict the future, of course, right? But it seems like there is still plenty of buying and selling going on, which is great for the industry. But then how does that affect the buyer or seller? So seller, we need to explain, once you go under contract, there's going to potentially be a pool inspector, an HVAC inspector, a roof inspector, a regular home inspector, on and on and on in that 10-day inspection period. And if so, are you okay that they each enter? We can make sure that they're wearing booties and or washing their hands, following all those recommended guidelines, filling out the access form so that we've done our due diligence. So I think that all, again, is part of the conversation, and we can determine then whether or not seller says, yeah, that's fine, I just need the house sold. Or if they say, maybe I want to hold off, I don't want that many people in the house, I didn't realize, and then you can make a decision on how to proceed that way.
That makes sense. And I think that the 10-day is probably is probably out the window right now. We're probably looking at least 15 to 20 day, right? I mean, because to get an appraiser out there is almost impossible nowadays. A lot of them just don't want to, or they're because of everything that they have to do to make changes to how they approach a house, might take a little bit more time. So they're just booked up. So
well, I know Northern Arizona or outlying areas of Arizona, you all have great issues with getting appraisers to properties that are more remote to begin with. Those are usually extended timeframes anyhow. Now add on top of that, I've been hearing maybe the appraiser is older and says, I'm in that high risk category, I don't want to take orders right now. So now the number of appraisers even willing to go out to those remote areas has been depleted. So it all needs to be a conversation, and we should all follow that guideline of everybody trying to work together during this difficult time to try to reach that common goal of getting a house bought or sold.
Fantastic. Okay. And so the COVID-19 addendum, can you give us some some highlights or your
Absolutely.
interpretation of the COVID-19 addendum?
I have received so many calls on this addendum. First, it was clauses. They were trying to move quickly, which I so appreciate, but everybody was like, what do we do with these clauses? And then a few days later, fortunately, the addendum, but I still am getting a lot of feedback on the addendum. And here are my takeaway points, okay? Now, the COVID-19 or coronavirus addendum, which again, you can all find on Transaction Desk or whatever you're using. The information I'm going to give now, again, remember, I'm not your attorney. You should consult with your attorney. If you're not a broker, consult with your broker and follow their guidelines. This is just general opinion by me. So first, lines 5 through 11. This starts off with the coronavirus pandemic has impacted transactions in unique ways. It's unprecedented, and essentially we don't know how it's going to affect everything. And it says, in this because of the unprecedented nature, buyer and seller are advised to seek appropriate counsel. And then it gives that list. So lines 5 through 11, I think would be advisable to have everybody execute, whether you already had a transaction in escrow when this was released, or if it's created at the time a transaction is formed. I like this because I always see the worst case scenario, right? When it turned into a lawsuit, I always call myself the Debbie Downer. I always have to think, how is this going to really blow up on somebody? 99.9% of the times, everything is fine. It's that, whatever 1% chance or less that we end up in a lawsuit. And so that's my concern. How do I have to worry about that? Now, we know there is a Department of Real Estate guideline that says we should always advise our clients to seek appropriate counsel because we aren't experts in those other areas, just real estate. And so lines 5 through 11 meet that guideline. It's putting in writing saying, we're not experts on the coronavirus. And if you need guidance, you should seek appropriate counsel. And then it has a line for buyer and seller's initials. I think that's fantastic. If I was an attorney defending you and somebody elected to sue you because, by golly, you were the listing agent and you allowed people into the house, you didn't forewarn me that I could contract the coronavirus, and now I've got the coronavirus. It had to be somebody that came into my house. This is me extrapolating. And listing agent, it's your fault, right? I mean, that's the conversation I'm seeing from different resources saying, gosh, do we have extra liability now? And so this, I think, and for anybody that's taken a class from me regarding risk management, this to me is one of those shields, right? In my class, I always talk about risk management is a shield. It's one more layer of protection to keep you from getting sued. And so I love this first section. I think everybody should be using it because it's a risk management tool. It helps protect us by making a written disclosure. Okay?
Fantastic.
So then there's a big bold print and or a big bold line. I point out that big bold line, for me, the risk management committee is letting you know that first clause really is a good section for everybody to use. Now a big bold line. Now we've got 4 options and those may or may not be used. You don't have to mark any of those 4 boxes if you don't want to. You could use sections 5 through 11 standalone as a disclosure. Okay?
Okay.
Then it says, starting on line 15, only those items checked are to be included in the contract. And again, it's not meant to mark all 4. It's usually only 1 box is marked. To begin, line 17. If we know we needed to have the transaction postponed by a certain date, it's right there. We just mark line 17 and fill in the date. And that could be the example you and I discussed. An appraiser it's difficult right now. We're being told we are about 1 month behind and then everything will go through. Okay, so maybe I'm going to put, a month, 6 weeks extension for a close of escrow date, and that's all I've changed. All the other terms and conditions remain the same, and so then I'm only marking box 17. Box 18 and 24 are very similar, and you can go onto AAR's website And they have an FAQ section on the COVID-19 addendum. And so if you forget what I'm saying today, it's all there in print for you, okay? So go to the COVID-19 addendum FAQ page from AAR, and it's there for you. So 18 and 24 essentially say that there is a possibility that the buyer, their lender, the seller, or the escrow company, or the recorder's office could be subject to a voluntary or mandatory COVID-19 virus quarantine or closure. And should such an event occur, then it says the buyer and seller agree that closing may automatically be extended by either party by written notice. And it says for a period of up to 10 days after the quarantine is over or the closure is lifted. Now, that's 18. That's essentially what 24 says, but 24 puts a cap on it. Starting at line 24, that says if there's a closure, quarantine, etc., we automatically extend for up to 10 days after the quarantine is over. However, it says the delay shall not exceed 30 days. So the parties can each say, we're good with extending, but once we hit 30 days, either of us may cancel because it's just getting too long. Maybe the market's changed, who knows what. So after 30 days, it says upon the expiration of any automatic or agreed extension, then either party may terminate this agreement in writing without any further liability, and the earnest money goes back to the buyer. So both are similar in automatic extension and then close within 10 days after the quarantine is lifted or closure is lifted. But the second paragraph says, but only with a 30-day max, and then either party could cancel. And then line 32 is just mutual cancellation. AAR, we've never had a mutual or a cancellation form, right? When I was on the legal hotline years ago, people would call in and brokers would say, you know, is there a cancellation form? And I'd say no. And as a matter of fact, I wrote the article, I think it's on AAR's website, that says there is no standard cancellation form. We do have now the notice form, so that could be provided as well. But here, this addendum, it's already filled out for us. Buyer and seller mutually agree to cancel. Buyer gets their earnest money back. So that's line 32. I will tell you as an attorney, and I know AAR has similar thoughts on this, there are concerns regarding the language. AAR gives an example of why the term voluntary was used, because it may be difficult for an individual to get in to see a doctor, and so they may voluntarily self-quarantine. But there is a concern about voluntary quarantine being abused. And so AAR, I know, has said additional language can be written in on page 2 where it says additional terms. Brokers who have consulted with me, I've given them additional language to write in there regarding you know, non-abuse of that voluntary clause. I always give an example of two true stories I know. My sister, in fact, lives in Georgia. She is immunocompromised and would definitely not do well if she were to contract this virus. And she lives in Georgia, where there's a hot spot of COVID-19 activity. She ended up developing pneumonia and was very sick and had definitely symptoms of having the virus. She was not able to get a test, and so her doctor asked the whole family to voluntarily quarantine themselves until tests could be obtained and until the results came back. So that was a valid voluntary quarantine under a doctor's recommendation. Good news is she got the test, it was not coronavirus. There is another individual who has severe asthma. And I was told he was laid off. He worked in the restaurant industry. He was laid off, and he is very afraid of contracting the virus because he has severe asthma. He has chosen to self-quarantine himself because he is afraid of getting the virus, but it's not under a medical professional's guidance. So that's why I have a little concern about the voluntary language, and why I think it's a good idea to add in any extra language that a party needs to feel more secure that the voluntary quarantine would not be abused.
Okay, fantastic.
Yeah.
Okay, so thank you so much for that. That was fantastic. A lot of information there. I hope everybody got as much as they can. And so we do have some questions, if you don't mind, if you want to stick around a little bit. So while we were given the interview, we had people that made comments, and so let's see. So Tina Seeley, she's our president-elect. She's going to be our 2021 president here for the association. She was asking if you'd heard how realtors and other independent contractors will access unemployment benefits. What are the parameters for that, seeing how we are considered essential?
So that question technically hasn't been answered yet. I was just listening to a live meeting today from NAR, and NAR's counsel says it is actually not clear right now on how realtors qualify for the unemployment benefits. And so I would recommend to each of you to follow up in watching NAR's website, and they've got lobbyists and they're working closely with Congress regarding how that will all come about, essentially. But one of the attorneys for NAR, just this morning I heard her say they don't actually have it quite figured out yet regarding unemployment for independent contractors.
Okay, fantastic. Connie Gould, she wanted to have it mentioned that we all love you, Jesi.
She's funny. I love you, Connie.
And then let's see here. So Kathy Swan, she would appreciate if you could touch on advisability and liability for agents doing video walkthroughs, inspections, et cetera, on behalf of buyers.
Good question. Of course, there is liability, and this is COVID-19 or non-COVID-19 scenario. As a previous broker, which is my background, right, I would always advise agents to be very cautious. As an example, I can give you my personal scenario. Years and years and years and years ago, when I was selling real estate, I had a great client from Canada, and we had a good relationship. He was buying houses here in Arizona. He was not able to do the walkthrough, and so I went through with video live and did the walkthrough for him. But to protect myself, I had him waive his final walkthrough. In other words, he wasn't relying on me to do the walkthrough, and I had him sign a waiver that said he did not rely on me being there to use that as his final walkthrough. So I think there is some concern about doing video for your clients. I can tell you, pre-COVID-19, there were definitely lawsuits for agents who did walkthroughs, etc., for their clients. But again, it's a handful. How many agents have done those video walkthroughs, and there is no lawsuit. So I think you need to talk to your broker and make a decision on what your brokerage policy will be. If you're going to do video walkthroughs for your clients, then I would just suggest possibly some type of liability waiver explaining that, you know, you're only able to see what you can see. You're not investigating and opening door or opening walls or doing any type of invasive inspection. You're just walking through with your video or phone or whatever technology you're using.
Okay, fantastic, good advice. Richard Laser, he had a question about NAR and new construction to accept the new coronavirus COVID-19 addendum. That probably will go, you know, we're going to send something to NAR for feedback, but at the same time, my screen just did something weird, sorry about that. Do you have any comment on new construction?
Well, as the buyer's agent, I assume we're talking about, right? For new construction, we're only going to be representing the buyer in that scenario. I would still use the COVID-19 addendum and at least have my buyer initial it. Can I require anybody to use the COVID-19 addendum? No. As a matter of fact, one of the brokers that I represent called me last week and said, we have a buyer that does, and we represent the buyer, and they don't want to sign the addendum. I gave her some advice and basically said it's not going to be a problem as long as you can document that you gave them the addendum and that they elected not to sign it. I now have proof that I at least gave the disclosure, right, with or without their initials. So that would be good to document and put into your file.
Okay, fantastic. We already mentioned Terry. She had questioned about being an independent, having her own, not having an office, and if she needed an action plan. And yes, definitely should for audit's sake, if anything else.
Just so you know, I mean, I know Terry well. She has an office, right? The Department of Real Estate requires us to have a brick and mortar office. She's essentially saying she doesn't have an office that's
right
and open to the public. So she's asking if she still needs an action plan, I assume. And so, yeah, I know Terry has other realtors working for her. So I would still have some type of an action plan, if at the very least to address concerns for your agents who are out with the public, doing showings or having listings or working with buyers.
Okay, and then Dawn Morgan, she was asking if we should get a pre-qual prior to showing.
She's saying, should we have the disclosure filled out and that sent with the pre-qual prior to showing? So in other words, she's talking about, should we be qualifying people? And that is a question I've heard before. In other words, before we just allow anybody into the house, should we, number one, make sure they're qualified to buy, so we're not allowing people into a house and increasing risk for the seller? It's a valid question. And now she's saying, and what about lines 5 through 11? I mean, for that fact, if we're going to do that, it's going to be a pre-qual, lines 5 through 11 of the COVID addendum, and the model access form, right? Have you been sick? Have you traveled? So you could elect to have that as your policy, if that's your broker's policy, before you work with a buyer. But again, fair housing, it must be applied to everybody then.
Okay, fantastic. And then I did see something, another question from Tina, but I can't find it right now. I think it had something to do with, she went to okay, I've been to the DES website, but didn't find anything specific to us.
Oh, for the, is that for employment? Yeah, my answer was, I think that.
Oh, okay, yeah, that's part of the, okay.
So that's probably part of the issue. Also, for those of you who follow me on Facebook, I just posted the latest executive order. It was just issued yesterday. I had been asked whether there were some further considerations that we should be discussing about other service providers. And on my list, I forgot to mention, right, a discussion with your client about title companies. Now, ironically, I've represented title companies as well before, and I know it was legislation passed last year that Arizona was going to become a remote online notarization state. It was kind of a big deal. And it was set to go into effect in, I believe, June, or maybe it was July. Sorry, I'm forgetting the month. It was June or July of this year. And Governor Ducey's newest executive order, 2020-26, is now in effect. And it states that they are going to move up that time frame. So where before, let's say it was July, that the remote online notarizations were going to be allowed, now it's April 10th. So in a day or two here, it's going to now be that by emergency order, executive order, the title companies are going to be able to do remote online notarization. Now, this is important because I've got clients that are title companies, as I said, and I checked in with one of the big ones, and I had asked, I spoke with a escrow officer, as well as I am good friends with one of their underwriters. And I asked them both by separate email, what issues are you seeing with notarization, and are you allowing remote online notarization? Now, the escrow officer said they had been performing remote online notarization. Most of these title companies are already set up and geared up because they knew the law had been passed and it was coming this summer. So it requires certain programs. It requires certain documentation of how they're doing it. And it involves, similar to what we're doing here, video. And so title escrow companies had been saying, yes, we will do these now in response to our COVID-19 crisis. But I was told specifically that many lenders were rejecting those online notarizations because in fact, she said Wells Fargo across the board had rejected all of their remote online notarization as a lender because they could not then turn around and sell it in the secondary market, was their position. And the escrow underwriter had said, we will allow remote online notarization, but we're putting an exclusion in our policy. And having defended those, so if you are buying a property and you get title insurance, and people always wonder, why do you need title insurance? I have defended many title insurance claims. I worked for a firm and our clients were title companies. And so when a claim came up, it would be assigned to us and we would defend that buyer. And this is a claim that we've had where the notarization was claimed to be false. And so we had a lawsuit. And so it is a realistic question, and you would want that coverage in your policy. And so before this order, the escrow company was saying, no, we're going to write an exclusion. If you want to use remote online notarization, then we're going to write an exclusion to that in our insurance policy. So with all that said, I was prepared to say all that, but then this executive order came out. And I think that's going to have to change that conversation. Now, by state order, it's saying, no, remote online notarizations are now allowed. The law was going to happen in July anyhow, so now it's going into effect April 10th. So I don't know that lenders will be able to so easily say they're going to reject it. I think that position now may be changing, and it's about to go into effect, so we shall see.
Okay, fantastic. I don't see any other, there's a couple of questions for Amanda, but outside of that, is there anything else that you feel that all of our agents or brokers should know that we haven't covered?
Let me look at my notes really fast and see if there was anything else. We talked about fair housing, screening. Oh, there is a question whether a waiver should be signed. Now, this model accessibility form is not a waiver. The model form put out by AAR just asks the important questions. Have you been ill? Have you recently traveled? These are the common questions you would ask to see if perhaps this individual might have been exposed to COVID-19. There are many discussions nationwide regarding liability for agents and whether we should have some type of a waiver before the house is shown. And there was comments by some folks, well, what is a waiver going to do? Will it really protect us from liability? That all remains to be seen. I remind everybody, pretty much you can be sued for anything as long as you have a valid claim. The court's going to hear your lawsuit. And so a hold harmless agreement usually protects a third party from liability if another party's injured. Again, how is this plaintiff, in my scenario, it's a seller saying, I'm going to sue you, agent, because you allowed somebody in and now I got COVID-19. But unless that seller was a hermit and literally never left the house in the past 2 months and can say nobody else entered the house but these buyers, it will be very difficult to prove that they got COVID-19 as a result of it being listed and then the listing agent didn't tell them. But regardless, there are some people saying, well, maybe I would do a waiver anyhow, just because it's another layer of protection. And I did print a couple of examples that many states are saying, waivers may not give us much protection, so we're not going to create one. But there are other state associations that have created waivers for their population, for their realtors. And so this is one from a state that basically says the current COVID-19 pandemic orders individuals to stay at home whenever possible. The undersigned understands that exposure to disease-causing organisms, etc., could result in illness. And so you fully and carefully consider all the risks, and you assume the same and agree to release and hold harmless the broker. So the question is, would a waiver like that be helpful? Nobody can predict the future. These waivers have not gone through the court systems, so it's difficult to say whether, yes, they were, right? There's the legal premise of assuming the risk. I go ice skating, I fall, I break my arm, I try to sue the skate rink because I broke my arm, and they're gonna be like, you assume the risk. Everybody knows ice skating is dangerous. You're out on ice, it's slippery. And so the question is, do we assume the risk by allowing the house to be shown while there is a pandemic? Arguably, yes. So I think that that these claims won't get far, hopefully, but some folks are electing to do a waiver, many are not. So I think that's an individual broker's decision on how they want to proceed with that.
Okay, and we had Dawn Morgan, she had asked, is there any way for a brokerage to get a copy of those types of forms from other states that people are using if they wanted to?
Well, two things. Most state associations forms are copyrighted. So you wouldn't be able to just use those forms because they're copyrighted to that state association. So if you're interested in a waiver, either create one yourself or consult with an attorney to draft one for you.
Okay, thank you. And what about evictions? Have you heard any? I heard, or I thought I saw something come across from Ducey's office this morning about evictions.
I don't know if I saw anything this morning, but it is 2020-14 is the executive order, I believe, that says evictions are stayed for 120 days if they are a result of the pandemic. And I'll give you an example. I'm just about to file a lawsuit against somebody who is a holdover tenant and hasn't been paying rent for over a year. He's refusing to leave. And so now finally somebody's come to me and said, please help me. And so I'm about to file an eviction, and my paralegal said, well, wait, we can't evict. There's a stay, right? No, the executive order says as a result of the pandemic. This was a year back. So I'm proceeding with that eviction. But if you have any questions, you should consult your own attorney to determine whether or not you could proceed with an eviction. But if it's anything that resulted from these last few months where the pandemic has been escalating, I would say you're probably going to fall in that clause of 120-day stay, no evictions. And let me tell you, my mailbox is inundated. I am getting alerts from everybody and everywhere, including the State Bar and the Arizona Supreme Court. And the courts are very limited. They also are following procedures. There are all of the remote Superior Court locations are closed down. There's only one Superior Court running in downtown Phoenix right now, and they are only running out of one tower. And again, you don't even often get to interact with the judge. They're bringing the papers back to the judge, and so it's very restricted. And the whole legal calendar is messed up, and everything is telephonic unless it's absolutely necessary to be at the courts.
Okay, fantastic. Well, thank you very much. This was very enlightening. I hope everybody got as much out of it as I did. And I really appreciate your time and sticking with us.
I think there's one last question. Somebody sent me a quick Q&A that said, can tenants who reside in a home that is in escrow prevent inspections during the inspection period, even when proper notice and COVID precautions are in place? This has been a question I've seen floating around all over the internet and on forums. And so I'm not going to be able to give you a solid answer because I'm not your attorney. There is the Landlord-Tenant Act that says a tenant cannot interfere with the landlord releasing the property. So I would likely say you would have, the tenant should consult counsel on whether the lease was terminating, or if they can get a month to month. If they're not going to be moving out, can they get a month to month to stay in? But there are, it seems like a simple, straightforward question, but it's not. It's pretty loaded. I can go down several different paths on whether I think the tenant may or may not have some objection. I think there's some question of, you know, accommodating the tenant, but I think that in general they cannot prevent the landlord from having the property shown if the lease is about to expire.
Okay, fantastic. Marcy, can you hear me?
Thanks, Kathy.
Yes, I can hear you.
Okay, I'm gonna turn it over to you. And thank you, Jesse. I appreciate it very much.
My pleasure.
Thank you, Jeff. Have a good one.
You too.
Well, thank you so much, Jesse. That was very, very, very informative. We had several questions come in that Jeff was mentioning to you as well. We will be able to, we did record this, so we will be able to post this on our Facebook page and possibly Recess, so that other people can watch it as well that couldn't make it today. So once again, we appreciate you agreeing to do this for us. Everybody has been commenting how very informative it was, and they very much appreciated you taking time out of your day to be here with us. And we hope to continue to be in communication with you for the future.
All right. Thank you so much.
Thank you. Thank you, everybody.
Everybody.
Have a great day.